And we're off. Right out the gate. Judge is making sure everything is by the book. Notice how quickly the court establishes the charges and rights. This is about locking in the record before things get heated.
Court is calling 2025 CR 003791, State versus Andre Xavier Crawford. Could I have parties announced for the record, please?
Ethan will be for Mr. Crawford.
And are you Mr. Crawford?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
I have.
Court will find that the state is in compliance with discovery. Mr. Crawford, did you review the document entitled Application for Deferred Adjudication with your attorney?
Yes, ma'am.
Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Judge.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Crawford,
Here's the kicker. This isn't just a slap on the wrist. A state jail felony can mean up to 2 years behind bars. Think about it. Stealing iPads from Target could cost you 2 birthdays in prison. Do you think that's fair punishment? Or too harsh?
did you review court admonishments with your attorney? Did you understand it?
Yes, ma'am.
Did you sign it in all the appropriate places? You're charged with theft of property, $2,500 to $30,000 as a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Crawford, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Did you understand?
The money part. Courts don't just punish, they want payback. Almost $3,747 to Target. That's not just a fine, that's restitution. Basically, Target gets its pound of flesh.
By entering this plea, if you are not a U.S. citizen, you could be deported, denied naturalization, and not allowed re-entry into the country. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $0 fine. State recommends deferred adjudication. There's to be restitution in the amount of $3,746.99 to Target. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions.
Here's a clever move. No contest. It's like saying, I'm not guilty, but I'm not fighting either. Why? Because if Target sues him later in civil court, this plea can't be used as an automatic admission of guilt, smart legal strategy, or just a way of dodging responsibility.
That have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there been any such motions?
No.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 5 years. There be a TAP evaluation, 200 hours of community service restitution, no contact with Target, and Michaela, Makhayla, Pean, Pean, a mental health evaluation, follow recommendations, the anti-theft course, and healthy relationships course. Did you understand those were recommendations by the state and the court does not have to follow those recommendations? Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
I believe the paperwork says no contest.
All right. Do you understand what a no contest plea is? You're not saying that you're guilty in layman's terms. You're not saying you're guilty. You're not saying you're not guilty. You're just not fighting the charges against you. However, I can still find there's sufficient evidence to find you guilty. But because you've applied for deferred adjudication, if I follow your agreement, I'm not going to find you guilty. I'm going to defer finding of guilt. Do you understand?
Yes, ma'am.
Normally, people will enter no contest pleas if there is any type of restitution is owed, because people can always sue you civilly. So sometimes your attorney is trying to protect you civilly. So by pleading no contest, if there is a civil suit involved, whoever wants to sue you out of something that arose from this incident, they would have to go to a civil court and prove that. Do you understand?
Yes, ma'am.
So are you pleading guilty or no contest?
No contest.
All right, state any evidence to support the defendant's plea.
State offer states one in attachment.
No objection, Judge.
All right, did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, so here's my question. I see that they say that he stole Apple iPad Air, which I understand. But in one place, on June 24th, 2024, they say he stole an Apple iPad and it costs, an Apple iPad Air, and it costs $799. Then they said he stole another Apple iPad Air and it costs $1,200.
This are based on like the storage space that the iPads have, and so like if it's like a 60 gigabyte, then that would be.
Pause here. Why a mental health evaluation in a theft case? Sometimes judges tack this on if the defendant's past behavior or related cases raise red flags. But it also raises a bigger question. Should mental health be tied into sentencing for theft charges?
Cheaper than a 120 gigabyte storage.
So the,
I think like ways to keep it.
sure. So the Apple iPads have different,
They have different
Storage.
storage.
oh, okay.
Yeah, so I did attach this, and so like
Okay.
here you'll see the storage on it.
Thank you. That explains it.
I guess otherwise you'd want to go shopping.
I'm sorry?
I guess otherwise you'd want to go shopping for the cheaper iPad with the same storage.
Oh, I have no idea. I don't do Apple. No offense to Apple. My thing is, I'm not trying to learn anything new, computer related. I still on my phone, which is, I think, a 6, and they're already on 29. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding you guilt as you've applied for deferred adjudication. So these are some questions I have. Number 1, why is there a request for mental health evaluation?
So the recommendations that are below the line are based on my analysis of a different case. So it was a global offer where he's not going to be on supervision for the misdemeanor case, but that's where the conditions are.
All right, so that's the mental.
This is classic courtroom negotiation, like haggling at a pawn shop, except it's for freedom. The judge doesn't just want promises, he wants cash on the table. $500 up front, or the deal could crumble. What would you do if you were in Crawford's shoes? Pay now, or risk it all?
health evaluation is based upon the misdemeanor case?
Yeah, the mental health evaluation, the healthy relationships, and then the no contact order with the named individual.
All right, and who is the named individual? What's the relationship to the defendant? Okay. All right, so then my next question for you, Mr. Crawford, when are you gonna have this $3,746.99?
I don't know exactly, but less than a year, for sure. Or less than like
When are you gonna be able to make a down payment towards this?
as soon as possible.
What does that mean, though?
I get paid on next Tuesday.
All right, what do you do?
I work at BJ's restaurant.
All right, so how much you're gonna be able to pay towards this?
I can put down 300.
300?
That's right.
All right, when will you be able to put down 500?
500. I don't know the exact date. But I have a phone on me.
Oh, do you want to look at a phone now?
I have my phone on me.
Okay, oh yeah, you can look at it.
The 16th.
October 16th?
Yes, ma'am.
All right, so this is what we're gonna do. I'm going to sentence you. Norma?
Yes.
Are you able to recall this back on October 21st?
Yes.
All right, so you're gonna be sentenced on October 21st. Ms. Abrams, he's gonna have $500. Should he make that out to someone other than, all right. So he's gonna bring in $500 towards Target. And then when you come back on October 21st, you need to be able to tell me how much you'll be able to pay per month towards this restitution. All right? So we're gonna recall you back on October 12th.
Did you put October 12th or?
I'm sorry, October 21st. Yeah, the days are just all over my head today. So we're bringing you back on October 21st. On October 21st, you're gonna need to bring $500. Do it in the form of cashier's check or money order. What do you need? All right, so either a cashier's check or a money order. And usually the money orders and cashier's check, they usually cost the same. So you can get the cashier's check or money order from a bank, or either you can get the money order from, HEB or some of those other stores. All right, so we will see you back then. Once you get the reset form and you sign it, you're excused, okay?
Yes, sir.
All right, thank you.
Judge, will you need me on that? Will you need me on that?
Oh, yes.
Okay.
Thursday.
Roy Sanchez Jr. Good morning.
Prior to today, we had an offer with a plea to another case in another court with a different defense attorney. This case would be resolved.
Mhm.
He's accepted the offer. However, while he signed plea paperwork on September 11th, there was a issue that court recalled him to the 18th. This case will be dismissed once he pleads on that other case.
So he's been recalled down there for the
I
18th?
believe so, but what they do is afternoon docket at 1:30 to like 3:30. So I'm asking if we could recall this to Monday the following week.
All right, everyone, please whisper. So that will be done on the 18th, correct?
Yes.
Norma,
Yes, ma'am.
recall this on September 22nd, and then if that is done, then we won't have him
Yes,
here.
Judge.
All right, so we'll see you back on September 22nd.
Thank you, Judge.
Thank you.
Follow the bailiff.
All right, the court is calling 2024 CR 009393, State versus Paul Anthony Ramirez. Could I have parties announced for the record?
Attorney Bill Simmons for defense.
And are you Paul Anthony Ramirez?
Yes, ma'am.
Okay, on this case, could I have the original motion to revoke?
Yeah.
I only have the first amended.
Good job.
Okay, thank you.
Excuse me, I'm sorry.
Mr. Ramirez, did you review the motion to revoke community supervision and first amended motion to revoke community supervision with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Are you the same Paul Anthony Ramirez who was placed on community supervision in 2024 CR 009393 for the offense of possession of a controlled substance penalty group 1, 4,200 grams on October 31st, 2024 for a term of 6 years? Is that you?
Yes, ma'am.
All right, state.
Violation of condition number 4 in Bear County, Texas, the defendant Paul Anthony Ramirez did then and there fail to report to the supervision officer as directed for the months of April, May, and June 2025 in violation of condition number 4.
How do you plead to that? True or not true?
True.
State.
Manager, Major Brown.
Any
objection.
objections?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, and sentence you up to 4 years in the prison?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
Yes, Your Honor. Is to grant the state's motion, revoke the defendant's community supervision, reform his judgment to a sentence of 3 years in prison. And the state is going to take into consideration cause number 2025 PF 31486 and 2025 PF 31487.
All right, and what are those allegations in those?
It's an unauthorized use, Judge, and a possession case.
All right. So what has he done on probation other than pick up new cases?
Your Honor, the times that he had missed, and it's, we have waived, those of allegations obviously have been waived, but if the court looks at the MTR, he was in Medina County for another offense,
All right.
fundamental.
So was he ever released while he was on probation?
You did report some of
Yes,
this, correct?
Do you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Paul Anthony Ramirez.
All right, so what have you done other than it's alleged that you picked up 2 new cases?
I reported like 3 or 4 times. I paid those times that I did go report.
All right, so you've reported 3 or 4 times since October 2024.
Whenever I was released from here, I reported like 3 times. Three times.
So why are you only reporting 3 times?
Because after that, I was in Medina County.
And in custody in Medina County for what?
Unauthorized use.
All right, and is that an unauthorized use that's alleged to have been committed after he was placed on probation?
My understanding is yes, Your Honor, but out of an abundance of caution, would just simply ask the court, or we have the summary here. I'd like to, just take a look at the dates just to make sure, but I am pretty sure it was after.
Yes, sir.
It was after the new charge after you got released.
Yes, sir.
So then here's my question for you. Why should I give you less than what you bargained for when the only thing you've done is report 3 times and you picked up a new case, you ended up in Medina County, and then you have 2 new charges here that the state is taking in consideration? And I'm assuming those 2 new charges, was that after he was placed on probation?
Yes, Your Honor, they were August.
So why?
Well, these cases didn't have nothing to do with me. As far as the unauthorized use,
Okay.
how it all happened is, if you look into it, but
And what were Your Honor, on the unauthorized use here, basically he was with but I would think that the evidence would suggest, I don't want to put words in about, the evidence would suggest that the actual taking of the vehicle was by another young lady in Corporate Christie that he had an engagement with here in Bear County that may or may not have involved provable possession of illicit substances, Judge. But it's not, but in no way are we trying to represent to the court that it's acceptable behavior as on while he's on probation. We would ask the court to, though, give some consideration, even though we've been here before. This is a young man who's basically been raised in prison. He went to prison for the first time at, I believe, 14.